over today. And before I did that, I just wanted to kind of give you guys a little bit about my background. And some of you I know and some of you I don't know. So I'm Julie Hardman and I am the Provider Compliance Coordinator here at the board. I've been working in this field for almost 30 years in various respects. I've worked with kids birth to 3, I've worked with adults, I've done a SAS, I've done a quality assurance specialist. So I've done kind of a lot of different things. I just kind of wanted to give you my background. Also, as far as background checks and compliance, I've been doing that, like I told you, it's been almost 18 years that I've been doing that. So I've learned lots of different stuff along the way. And so those of you who know me know that I'm kind of black and white and I like to figure things out. So if I don't know, I want to find out and I want to know how something works. So I'm here to kind of share what I've learned along those 18 years in regards to background checks. Background checks we do, when we look at those during compliance reviews. So it's something that our department looks at quite a bit. And I'm not going to say that we're the experts on that because a lot of times you'll find something that you have never ever seen before. So our stance is here, if we can't figure it out, we're going to consult to get a definitive answer. So there are some things that are very black and white and some things that are not so much. So get started. So it's not going to go. That's not going to go either. Okay, technology is not my thing. I'm going to tell you that right now. See if we can do that. There we go. All right. So our objectives for today. We're going to talk about registry checks and background checks and what's required for providers. You're going to learn how to read those registry checks and background checks that have stuff on them, issues. The ones that don't are very easy to read. The ones that do get complicated. And you're going to learn resources if you need help. So just to jump in, requirements for agency providers, database checks have to be done prior. And the state says, go ahead and do those first before you send the person for the background check. Anybody know why you might have to start with the registry checks first?
Because if they fail any of it, they don't clear on any of these, there's no sense in them getting.
Exactly. There's no sense in spending money for the BCI if they're already on one of the registry checks because you can't employ them. So here's a list of all the registry checks that have to be checked. It can be done through ARPS. Kind of condenses some of them and puts some of them together, except for the ODM exclusion and suspension list isn't on ARPS, and neither is TSAMS. So if you're doing ARPS, it gives you a bunch, just not all. So you're checking these. What if an employee is on there? What if Sam Smith? We look up Sam Smith. And Sam Smith is on, let's say, the abuser registry. What else would we want to do?
Maybe it's the same Sam Smith that's on that you got, maybe a different person.
Yeah. So you're looking, is it just a name match? Because especially if somebody has a very popular name, might just be a name match. So you want to match up birth dates. You can match up the last 4 of the social security number on some of the registries. So you want to try to figure that out. If you can't figure it out that way, there's always a number at the bottom of the registry check. You can call and they can help you work through whether or not that's actually a match. And you want to make sure that if you get any information that clears that person so that they're able to work, you keep that documentation. So when we come for a compliance review and we see Sam Smith shows up on the abuser registry, you can say, well, it's not the same Sam Smith. The person has a different birthday. And here's where it shows up. If there's a true match, you can't hire that person. We've had some people that are on, like, the ODM exclusion list has been a big thing lately, of people coming up on that. So you definitely want to check that. The BCI FBI checks that are required for employees has to be initiated prior to hire. That's in the rule. FBI check, if the person has not lived in the state of Ohio during the 5 years prior to employment. So how do we, any ideas how we figure that out?
Ask us. Their last address, the addresses that they lived in, or
You can look at the address that they lived in. You could look at, we've had some people show us, they've looked at tax records. You've had some people will look at their license and okay, their license is about to expire and it's a 5-year license. Makes sense. Some people do, like here at the board, we do an affidavit that we have to sign and notarize saying that yes, we have lived in the state of Ohio. So any of those things are acceptable. Basically, during a compliance review, you need to be able to show proof of how you determine that. And there's no right answer to that. So like, the correct reason code for a BCI and an FBI check has to be used. We'll talk about that in a minute. But anybody, know why the reason code is so important?
They do different checks for different people.
Yeah.
It's
Yep, different reasons pull different code. So very, very important. And a person with a disqualifying offense cannot work in a direct service position unless the exclusionary period has passed. So, like I said, what's all the fuss about reason code? So the reason code identifies the list of offenses to be included in the background check. DODD's reason codes also open sealed record. And sealed records count when determining whether or not the person has a disqualifying offense. We've had providers come to us and go, okay, this employee brought in something from the court saying this record is sealed. So we shouldn't look at it. No, the only reason we don't look at something is when it's actually expunged. And when it's expunged, there is no record of it. You can't look it up on the court system. It's like they just wipe the slate clean. And typically expungements don't happen very often. Sealed records can happen, but for us, it doesn't matter. We still look at those. We still get those with the BCI if you use the correct reason code. So reason codes. These are the acceptable reason codes for FBI and for BCI. And when Danielle emails out your certificate, she's also going to email out the copy. So you guys can do that. So very important reason codes. So once the employee goes for a BCI or FBI, and they work.
yes,
Yes, if.
60
you
days.
have the other
If
credentials,
what though? We
the
have
other
to have-
credentials.
We have proof that they were.
We have to have proof that they went for BCI and FBI if they need it.
And they had to sign the letter of.
Uh-huh. And the registry checks have to be done and they have to be clear. Additionally, all required trainings have to happen. Like CPR and first aid. So if all of those things are in place and you're waiting for the BCI result, it's acceptable for that person to work. You have 60 days to get that BCI back. So what happens when it's 60 days and you don't have the BCI results?
They can't work anymore.
Yep, they can't work anymore. You have to pull them from the schedule until you receive them. We've had some providers that will send employees for a BCI check and don't require a receipt or some kind of evidence that they actually went, which has been problematic because that 60 days comes and goes and that person can't work. And then you find out, well, that's because the staff never went to get one. But the rule says 60 days. So if you don't have the results back, you have to pull them from the schedule. No matter what the reason is. Sometimes BCI gets really backed up and it takes a while. So what if there's a conviction on the BCI or FBI report when it comes back? They have stuff. It's not a clean one. It doesn't say, you know, that the person doesn't have any offenses. We're going to look at the rule. And the rule lists out, if you have not looked at it, I would look at it. The rule lists out different tiers and different offense codes under different tiers. It's not something that, like, we don't have it memorized. I can tell you there's certain things that we see a lot, so I know where those apply. Like, I can tell you assault is a 5-year exclusion just because we see that a lot. But you're going to look that up. So you're going to look up what they're actually convicted of. So they might be charged with something. It might get pled down to something else. So you have to look for what they're actually convicted of. If there's a disqualifying conviction, you're going to determine whether or not the exclusionary period is still in effect. So if it's a 5-year exclusion, depending on when that happened, they might still not be able to work. And we're going to go through some examples on kind of how that works too. Amy, you look like you have a question.
I do have a question because doesn't it have to go like after their 5-year exclusion, whatever probationary period they had as well?
Yep, and that's coming up in the next slide or the slide after that. I also want you to know that the tier the offense falls under determines the length of the exclusions, but also multiple disqualifying offenses, the convictions extend that exclusionary period, and multiples get really confusing. There's going to be a slide that kind of explains that too, but it basically ups the ante. So if you have somebody who is not a very good girl and they do multiple things, it ups that ante. So if you find that there's a disqualifying offense and the employee still work,
Depends on the exclusionary period.
yeah, you have to figure out, is the exclusionary period over? So if I did something back in 1995 and it was a 5-year exclusion, I'd be able to work, provided I didn't continue to misbehave. So yeah, you want to go through and figure that out. The exclusionary period, like Tammy said, does not start until official discharge from the criminal justice system. So that means, and it's really, the onus goes back on the employee to prove when they were discharged. There's multiple ways of doing that. Individuals can go to the court and get something from the court saying, I'm discharged from this on this date. You can also look up in the court websites to see when the person was discharged. So that means when they're, like when any jail time was completed, when the probation was done and it was done successfully. We've had some people that, okay, on the surface, it looks like they can work. It's a 5-year exclusion. It's been 5 years. They only had probation for 6 months. It's been 5 years, 6 months they could work. But when you dig deeper to see when that person was actually discharged from their probation, they were not so great. They got their probation extended. So that's why it's really important to get that information, because some people don't do that successfully. Sometimes it has to be extended. And sometimes we've seen where, somebody is, really made a mistake and perhaps their probation, they're discharged from it early. So we've seen that too.
The fines have to all be paid for as well.
The fines do not have to be paid. So you're looking at any kind of incarceration time and probation. The fines don't matter.
Those dates can be tricky too, because sometimes they might have said they committed a crime in 2015, but the police didn't catch them until 2019. Gonna push their time back.
Yep. You're always gonna look at that conviction date and what they're convicted of, as well as like if there's any kind of incarceration time and probation time, and then start that exclusion after that. And it's the provider's responsibility to verify discharge from the court system. So it's your responsibility as a provider. But we've had staff go back into the court and say, I need something showing when I'm done with probation. The court will give it to them.
So are you saying that if on someone's BCI, it says like probation period, probation, like 12/2/22, you're saying don't go from that date, like look into the court system? Let's see, okay.
Because realistically, if it says probation for 2 years, and that 2-year time period is up, they might not have complied with probation and it might have gotten extended. And that's not going to show on the BCI. That will only show on the court record. So court records are one way to look it up. The other way to get verification of that is to have the staff person get something from the court. And if they want to work bad enough, it doesn't cost anything. If you go into the court, they'll print you something out. It's not that hard to do. So we kind of went over this. So discharge, you can ask the employee for evidence, which, and this is me. If an employee gave me evidence of discharge, I'm probably going to go look it up in the court records just to make sure. I've seen a lot in all the years, and I've seen forged BCIs. I've seen forged court record. Like I've seen lots of different things.
Diplomas, GEDs.
Absolutely. So when in doubt, verify through the court system. Or you can look up in the court system yourself.
Fines covered.
Okay. So we've been talking a little bit about some of the things that are in that, the rule and exclusions, and in the rule it talks about different codes have different exclusionary periods. There are some tricks to those codes. So I have a bonus question. What offense codes show up under 2 exclusionary periods in the rule? And how do you know which exclusionary period is correct? And anybody can guess. Anybody have a guess? Nobody? Or everybody's going to be quiet. I can be mean and I can start calling on the people. Oh. I'll give you a break because this isn't easy. And it's very weird because there are several that show up under multiple exclusionary periods. So we look 2925.11 goes up in 2 spots. It's drug abuse. And it shows up under 5-year and it shows up under no exclusion. And what DODD, because it talks about for a 5-year exclusion is a non-minor possession conviction. So like, what does non-minor mean? Because it doesn't tell you in the rule. This is one of those things that we've asked DODD lots of clarifying questions, like how do we know this? They define non-minor as a felony 1 through 4. So the higher level drug charges. So if you think about, and maybe you know this and maybe not, but I'm just gonna say it in case you don't. I mean, the way that works, there's felony. One is like the worst, like murder, manslaughter, like really, really bad stuff. And it goes down to felony 5. Then it jumps down to misdemeanor. So felony 1 through 4 is the 5-year exclusion. Felony 5 or misdemeanor is a no exclusion. That's a common thing that our providers trip up on because it lists it and it doesn't really tell you. Yeah. So I would keep, until you get the hang of that, I would keep the slide handy when you're looking at BCIs, especially if you come across that code. The other one that shows up in multiple spots is this, and it's under each tier. And so it talks about conspiracy, attempt, and complicity. So sometimes you have somebody who is perhaps charged with assault. And maybe it's pled down to attempt. In DOD's eyes, that doesn't matter. Whether it's an attempt, whether it's a conspiracy, like any of those, it goes back to the original charge. So it still is assault. And you're going to look at the exclusionary period for that original charge. So that's one that trips people up too, because it shows up under each one. So if you're solely looking for that code and you look at starting at the top, you're going to go, oh, guess what? It's a permanent exclusion. Because tier 1 is permanent, and that's where, you know, it starts in the rule. It might not be. It goes back to that original charge. Okay, fraud, theft, etc. So any conviction related to fraud, theft, embezzlement, breach of fiduciary responsibility, or other financial misconduct involving a federal or state-funded program, there is a permanent exclusion. The thing that we see most often, unfortunately, is Medicaid fraud. That shows up in this. The one exception is 291346, which is illegal use of supplemental nutritional assistance program for women, infants, and children. And that's a 10-year. Don't ask me why they did that. Doesn't make sense to me, but that's the only exception to that. Multiple convictions. So here's kind of a general cheat sheet. Each conviction has to be reviewed. So you're going to start out with the very first one they have and figure out, does this conviction carry an exclusionary period? And if so, what? Then you're going to go to the next one. The same thing. So it might be a 5-year here. It might be a 5-year here. And then you're going to go and look at this handy little chart. So, okay, it ups the ante. Where does it fit? So like here, when I said 5-year and 5-year, it's the very last bullet point here. Multiple exclusions carrying a 5-year. The last one gets bumped up to 7. So if you think about it, your last conviction is really getting bumped up in here. And that's kind of how it works. So like here, a 10 and a 7, or a 10 and a 7 and a 5, or a 10 and a 5, it's going to go to 15. The same with a 7 and a 5, it's going to go to 10 because the worst is a 7. The next here up is 10s. So multiples of the ante, it ups the ante on the very last thing. So it could be you have a 10-year exclusion from 1995 and they just got a 5-year. That's going to up that. It's not going to be a 5-year, it's going to be a 7-year. So that gets confusing too. Okay. We've talked a little bit about sealed records. So sealed records, basically it just means that certain people can't see them. They still exist. But there are exceptions that allow sealed records to be released. And that's where those codes are really, really important. Sealed record, in terms of convictions, do count for the exclusionary period. Okay. This is what, if you guys have not seen, a sealed record looks like. We don't come across these very often, but this is what it kind of looks like. So it still is going to have the offense. It's going to tell you what the disposition is. It'll tell you the date it was sealed. Now, if it truly is expunged, you're not going to be able to find any record of it. So if I go and look, and there are some charges that say somebody did something before they were 18, they potentially could get those charges expunged. If they're a victim of human trafficking, it means when you go and check on the court records, you won't see anything. It's like it's gone. Somebody just erased it. Okay. So we come across this sometimes too, where somebody's charged under a municipal ordinance. So might be the city of Toledo is going to charge somebody under riot. They're going to use their code. And the numbers are going to be different. So instead of what you typically would see, it's not going to be that 4-number dot and 2 numbers, like on the BCI. It's typically like 3 numbers dot 2 numbers. What you have to do is you have to try to figure out what that equates to. So say it's assault, you're going to look and you're going to find, how does that equate in the rule? Do I find the word assault in there? If it's riot, if it's, whatever the charge is, the charge language is typically the same. Every once in a while you get something weird. And that's where we send stuff to the ODD, because I don't ever want to say somebody can't work unless I'm 100% sure they can. So yeah, we have to just try to match the wording. Now, diversion programs. So there are things where there are diversion programs. Typically, this goes outside of the criminal justice system, gives offenders, typically first-time offenders, an opportunity to avoid a conviction. So I screwed up. I got charged for theft. It's the first time I've done this. I've been really good. That's the only charge I have. They might say, okay, we'll let you do a diversion program. That means I'm never going to get convicted of that. It's a diversion program. So there's no conviction with it. It happens prior to that court. You're going to see that on the court record. So it happens pre-trial, so no convictions. And the charges are dropped if the program completes. So if a person goes through the diversion successfully, they're going to drop those charges. So if somebody's going through a diversion program, say for theft, and they're still in the middle of that program, can they work?
Yes.
Who is that? Dave? Yes, they can still work because they haven't been convicted and they haven't pled guilty. Those are the 2 reasons why they can't. So no plea, there's no plea of guilty, there's no conviction. But yes, they can still work. It also means you have to watch, because do they successfully complete that? What's going to happen with them? Are they going to drop the charges? So you just have to watch. So there's also something about in lieu of conviction. So this happens during the trial period, and it requires a guilty plea. So plea of guilty, specific circumstances have to occur, and it basically postpones criminal proceedings in lieu of treatment, some treatment options. This does show up on a BCI as an in lieu of conviction. It does count for exclusionary periods because they have to plead guilty. That's part of that circumstance. So in lieu of convictions count. exceptions to the rule. So you can have somebody who has gone through this, like you've gone through the BCI, they've had charges, they've been convicted, but sometimes they're still allowed to work. There are exceptions to this rule. And these are the exceptions listed in rule. You can get an unconditional pardon. I've never seen that. An overturned conviction. I actually haven't seen that either. The most common one we see is what's called a CQE, or a Certificate of Qualification for Employment. Or they could have a Certificate of Achievement and Employability in a home and community-based service field issued by the Ohio Department of Rehab and Corrections. So those are the only exceptions. If they have an exception, you will want to keep that documentation in their employee file, because that proves that they're allowed to work. But I want to talk a little bit about CQEs, because that's typically what we would see if we see something like this. So it enables a person with a disqualifying offense to obtain employment in a direct service position granted by the common pleas court. Does not apply to tier 1 offenses. So those really bad offenses like murder, manslaughter, that kind of stuff, they're not going to give a CQE for. There's an application online. And you can go into the court system and actually open up, at least in the city of Toledo, you can open it up and see the actual application that this person had to fill out. They have to rationalize why they should be given a chance to work. And I've seen things like, okay, the exclusionary period that I had isn't quite over. It's almost over. I've been really good. I haven't gotten in trouble. So maybe it's a 10-year exclusion. That's the only thing they did. And they have like a year. They can make a plea to the court saying, look, I've really cleaned up my act. I really think you should give me a chance. The court will weigh in and it will say yes or no. But that actually shows up in the court record. And if you have, we have some staff people who, sometimes people do stupid things. And maybe they've been a good staff person and everything's been great. And maybe domestic violence comes to my mind. Maybe they get charged with something that, perhaps might not be entirely their fault. You can always say, you can go to this www.erccque.com. It will show the person how to do that, how to apply for that. Because, sometimes stuff happens. And ultimately the court's going to look at it and the court's going to decide whether or not to grant it. Okay, so BCIs. So what do BCIs with charges or convictions? Anybody had the pleasure of seeing any of these? Where it comes back with stuff. It cracks me up because, and I'm dating myself, but it reminds me of like a dot matrix printout. Like it doesn't look like it's something official. And so the first time I saw it, I'm like, what is this? And is this real? And yes, it's real. But if you have not seen one, oh, it's not on there. In the slides, because it printed out, however, it's not on here. And I can pass this around. This is kind of what one looks like. If you have not seen it, it looks like a dot matrix. So. And like I said, the first time I saw one, I'm like, somebody saved. Because that's what it looked like. So.
There's a couple.
Oh yeah, I've seen one, I think, the biggest one I've seen, like, is 6 pages long. Which, I mean, I do have to say, you get abused back. And yes, you might go through all of these charges, and yes, technically that person might be able to work. But yeah, you don't have to employ them.
Thank you.
Yeah. Because you're taking a risk. So I wanted to go through a couple of scenarios, and I'm just going to kind of read them. But I want to kind of talk about what else we might need to know. If we think the person can work. The scenario number one, an applicant was charged with assault in 2020. Assault, I'm going to tell you, so you know, you don't have to look it up. It's 5 years. So in 2020, they have a 5-year. But the charge was pled down to 2923.02 attempt. Do we think this person can work as of today? That's the first question. Do we need to know more? If so, what and why?
We need to know the sentence. We need to know what date. Because if it was in January and they didn't get probation or anything, they could work as of today.
Did everybody hear her? So basically what she's saying is we need to know when it happened in 2020. Did it happen in January? Because if it happened in January and there's no probation or no time, yes, the person could work. That 5 years is up. We need to know if there's any kind of jail time or probation. And if so, were they discharged? Okay, scenario two. An applicant was convicted of drug possession in 2022. And this person worked. Do we need to know more? If so, what and why?
It's the level of the drug offense.
Well, how would we figure that out? This one shows up in two different places. This offense shows up under 5 years and under no exclusion.
Court records. Court records.
Court record. We need to know, was it that F1 through 4? We need to know, if it's F5 or misdemeanor. What else would we need to know?
Exclusion.
Incarceration, probation. And if so, was it successful?
Charge.
I mean, those are all things we would want to know, but if you look at 2022, if we can pin that down to no exclusion or 5 year, it doesn't really matter if they got jail time or not, because we'd still be in that 5 year. Just because of the date. If it was a 5 year. Scenario 3. Right, well, that will be helpful for you. So scenario 3, an applicant was convicted of aggravated menacing in 2001, which is 7 years. Drug trafficking in 2010, which is a 10 year. And theft in 2023, which is 5 years. So 7, 10, and 5. Okay.
10 years.
So can they work?
No.
Right. We're still within that 15 year. And you're right, it is 15 year. I mean, at the very least, if they got no probation or no time, 2038. So a long time from now. So those were just some little scenarios to kind of work through. I also wanted to talk about, and we see this a lot, rat pack. So agencies are required to enroll direct support employees within 14 days of receiving their BCI results. 14 days is really, really important. So when you get your BCI results for somebody, you have 14 days to put them in RATBAC. And what RATBAC does, I mean, it basically continually checks for fingerprint pings, I guess is one way to say it. So if someone is enrolled in RATBAC and say they go out and they commit a crime and they're not real great because they didn't tell you. Why would I tell my employer I got it? Even though they're supposed to. RATBAC will actually notify you that, hey, they were arrested. They were charged with something. Now, just because they're charged doesn't mean that they can't work. Because the charge, they're not convicted and they haven't pled guilty. It means you need to watch. You need to watch and see what happens. So watch the court record. I have people that right now, there's 3 different employees or potential providers that I'm watching court records on. I have it on my calendar. Here's the next court date. And I'm going to look it up. Because once that person pleads guilty, or once that person is convicted, then you need to look at exclusionary period. And this is a citation in compliance reviews that we find a lot where people are not enrolled in RATBAC or not enrolled timely, because you get that BCI back, that's one snapshot in time. You have those 14 days. If you forget to enroll somebody till, 2 months later, if something happened during that 2 months, you wouldn't have been notified and you could be held liable for that. So very, very important. Okay. This, I think, is really, really useful if you're not familiar with RATBAC. There's a nice information and user manual. RATBAC is kind of its own beast, I guess. And it goes through the Ohio Attorney General's office. So like their manual tells you like how to enroll somebody. It tells you how to associate. It tells you like if somebody no longer is working for you, how to disassociate. It'll tell
That's
you.
also a fine.
Hmm?
People need to know that's also a fine.
Yeah. And you want to disassociate when somebody doesn't work for you anymore because it costs you money to enroll people in RATBAC. So keep track of that and keep it up. And in a compliance review, we're going to ask you for a specific report. And it will show you how to pull that report. I am not an expert on RATBAC. I can't tell you go in and click this and it'll pull up the report. But the user manual will tell you how to do that.
I just wanted to add a comment. We were recently doing some things with RATBAC and learned. I found it helpful. So I had to resend some people for new background checks because they went on leave. I disassociated them with RATBAC because I felt like I didn't know if they're really going to come back. I don't want to pay if they don't, thinking I could just put them back in. And I didn't know that when you disassociate, they cannot go back in. And then you have to get a new background check. And so just for other providers, if you have people that go on leave, stuff like that, you may want to consider, just we're moving to just a flat period. We're just going to leave them in to just avoid it all.
Yeah.
So thought I'd mention.
That's a very good point. And it makes me think of, sometimes you have people that quit and then maybe a year later come back. Means you have to do all this again.
Catch 22 though, if you leave them in the system. Because if they're not currently employed and they do a spot check on you, you're fined for them being in your system and they don't work for you. Because you're getting information about them that you're not legally allowed to have. Been there, done that. I'm speaking from experience. A provider that I was working for
It is a catch.
left people in there because, they might come back. A lot of people do this. They quit and then they come back. He left them in there and we were fined for every person that was in there.
I think that's a really good point. I think it depends on the person. So if you have somebody who's maybe going on leave because they're gonna be gone for 3 months because they have leave. You know, they're probably gonna come back.
Yep.
That's safe to leave them up. Or I'm taking a break for school. Like the
Yes.
plan is for them to come back. If you don't have a plan for them to come back, then it's-
Rec has a thing in there now that if somebody was forgotten and left in the system and it pulls and gives you something, you just disaffirm the entitlement and then you don't view it, so then you're not charged. You tell them no, that they don't work.
perfect. I did not know that. Thank you. Right. Okay, so another requirement. At least every 5 years, you have to complete a VCI if you're not able to enroll somebody in RATBAC. And there are some people that you cannot enroll in RATBAC. Those are people that cannot do fingerprints electronically. And we have some people like, there's a specific independent provider that every time she renews, she has to get actual ink fingerprints, because there's something about her that the electronic ones, they can never get them to read. So there are people out there that they can try and it just doesn't work for them, and they have to get the actual ink card. So in that case, they're not able to be enrolled in RATBAC. You have to do it every 5 years, and you have to keep track of that. You have to complete an FBI check if the employee has not been a resident of Ohio for the last 5 years. So we live close to a couple of borders. We have some people that, like even here in the board, there's people who live in Michigan but work here. That FBI check is required. And even if they're enrolled in RATBAC, RATBAC is Ohio-based only. So it will not pull anything for Michigan. So every 5 years, you have to complete an FBI check. You have to complete all database checks if they're not enrolled in ARC. Now, even if they are enrolled in ARC, you still have to complete a SAM and an ODM database check because those aren't covered under ARC. ARC functions very much like RATBAC, just for all of those registry checks except for the 2. So it will let you know if they show up. We had problems getting to ARC. How do you go? Remind me afterwards and I can get you some information about ARCs and how they might go about enrolling and fixing that. ARCs has had its issues just like RATBAC has. So sometimes it works well and sometimes not so much. And if for some reason you typically enroll people in ARCs and it's not working, then you need to keep track of those people that are not enrolled. Yeah. All right. I always like to talk about this. So best practice, not enroll. However, if I had an agency, I'm sorry.
I'm sorry, I just had a question about the ODM check. Exactly what is that?
That is the ODM exclusion and suspension list. Typically you land on that list if you committed Medicaid fraud. But it's a list and it's a very funky list. It's looks like a spreadsheet. At the bottom of it, there's individual and there's agency. And what you do is you go through and you search for that person's name and you do like a screenshot of where their name would be. But if they're on that list, they're not employable. And we have had some people that are on that list, or some people that suddenly show up that you didn't know were on that list.
And they do want to see that screenshot.
Yep.
When they come to do your reviews, they do want to see that screenshot. And they want you to date it when you did it.
Yeah, and depending on your computer system, like for mine, if I take a screenshot, it has the date at the bottom. Some people's don't. It just depends on the way your computer's set up. Or if you do like a print screen, sometimes there will be the date at the bottom and sometimes not. It's still acceptable to sign it and date it. Like that's okay. But yeah. Okay. So best practice. If I had an agency, I'd be looking at court records. Court records tell you a lot. Sometimes you look going, oh, I don't, even though I could employ them, I don't know that I want to.
EMC clerk of court, your best friend.
Yes. In Toledo, like they have an awesome system where you can find out a lot of info. Other municipalities don't necessarily have all that, or they have very minimal.
I'll link you to the affidavits and everything, so you can see like a description of what the incident was and everything. You know, and if I have somebody, then I look at their court record and they have 5 or 6 domestic violences that have all been dismissed because the victims failed to appear, I'm probably not gonna hire that person. You know, you don't just happen to have those or that many of things like that.
I also had a provider a couple of months ago. They did the BCI check and everything was clear, but we looked at the Lucas County courts, they were convicted and they just didn't tell the BCI about the conviction.
That's a big problem in Ohio. Municipalities don't always report to BCI, and if they do, it's not always timely. Some of them are very far behind and they're reporting to BCI because they were all paper records and they have to transfer those all over into electronic records to get them into BCI. Toledo is one of the ones that's really bad. They have a lot of old court records that have never been transferred over to BCI. So you'll find a lot of convictions when you look on Toledo Municipal Court that won't appear on the BCI itself.
I think that's a really good reason to look. I mean, yes, they're supposed to report and they're supposed to report timely, but that doesn't always happen. As a provider, if you've done what's required in rule, you've done the BCI, the results come back, you find out later, you get a call from me, because typically it will be a call from me saying, hey, we found this. This person was convicted of assault. It does not appear it's been sent to BCI, because you'll also see an entry where it's sent to BCI. But they need to be forthcoming. At that point in time, like, you're not at fault for not looking at that. That's not required. But once you know, then you have to pull those things out. So you can't act on something you don't know. But once you know, you have that responsibility. But looking at the court records, like, I can tell you from my personal experience, I was looking for a sitter for my kids. I'm looking at court record. And I'm going, okay, I know that was a while ago, but no. Because we all, we get in this field for a reason. And we really enjoy working with the individuals we work with. And we want them to be safe. So this is another measure that it's free. You don't have to sign up for anything. You're not going to get on like some weird email list. You don't have to pay money. It's a free resource to see, what is on there. It can also tell you, okay, maybe here's a theft charge. It was dismissed. Here's a theft charge. It was dismissed. Perhaps maybe I don't want, if I'm going to hire that person, maybe I want to put some safeguards in around people's money. The same with assault. We've seen a lot of people that, yes, technically the person can work and they have multiple assault charges. And yes, it was dismissed because the victim failed to show. Okay. Do you really want to take that chance? So, places to look. Sometimes you'll see things like on BCIs where, say, somebody was convicted of something in Butler County. Butler County has a court system. You can look up and see when they've been discharged. So every municipality has some type of system. Most are electronic. I don't think I've run across one that's not. Like, even I live in Henry County. Henry County, it's electronic. Fulton County is electronic. I haven't come across one that hasn't. The other best practice is whoever's looking at your BCIs, have a system in place to check the checkers, because we are all not perfect, me included. So you want somebody who's going to oversee that, to check and make sure, yes, we're getting these back. Yes, we're looking at them, because that's the other thing. Even if you get a BCI back, you have to look at it. We've had people that just, oh yeah, I got it back, I filed it. I'm serious. So yeah, have a system in place to check the check because we all make mistakes.
Thing we had to do because of a MUI, and it was a requirement now, DODD handed it down like this is what has to be in all your files. I had to create a form that says BCI acknowledgement that has two supervisor signatures on it. And that's in everybody's application.
And I'd be watching like, okay, what does that mean? Because does it mean yep, it's in there.
And it was because they looked up on the municipal and it was something that wasn't on the BCI that we missed. So they was like, make sure they pull the municipal, pull the Lucas County online dockets, because it's two different records. Because if it's something that bonded over, it's not gonna show up anymore on the municipal and it'll be on the other side. And they were able to pull all that we never saw because we were only looking at the BCI.
And that's a very good point. So when you look at the municipal record, sometimes you'll see a disposition and sometimes you'll see held or bound over, which means it went to the other court system. So there's another place to look. It actually went to trial. And I will have, when Danielle sends this out, I'll have her send some links out to I have them bookmarked for Toledo at least, so that you can see where to look for that. And like I said, if I Google Sylvania Clerk of Court, I can find it.
I have a question. So what you're saying, after you get the BCI, you still need to check the municipal and after you get all these records, you still need to check.
We do it before I even.
I do it before. I do it as soon as they come in for application.
Really?
Yeah.
Because the results of that is gonna determine whether I even want to do a BCI or not.
Oh, okay.
Because I have to pay for a BCI. I can do that for free.
Gotcha. Okay.
And it's not that it's required,
Okay.
but it is a really good step,
Practice.
especially since we have court systems that lag behind and stuff in the neighborhood. We want to protect the individuals we work with. All right, so I promised to give you some resources. When in doubt, consult with us. So there's a couple of ways, there's 3 different ways you can consult with us. You can contact your liaison, and everybody who is serving should have a liaison. If you don't know who that is, let me know and I can find out for you. You can call the Ask Provider Support number, the 381-6123. You can email to askprovidersupport@lucasdd.org. Or you're welcome to call or email me. Ultimately, what happens, Jim, what typically happens, I'm gonna pick on you. What typically happens when you get a BCI as a liaison?
I'll run it by you usually.
Yeah. I mean, typically, unless it's something clear cut, you have to running it by a supervisor. Just because usually if you're sending it, it's not clear cut. I think if it's something like, I get a lot of emails, so if it's something that's a BCI, put that in the subject line, because then I'm gonna open that up right away. Because I've had ones come in where, can you help? And I'm like, oh, with what? Like, it takes a minute. Where if I say, if you see BCI, like, I'm gonna open that right away.
We're not supposed to bother Dave.
Well, you can bother Dave. And if Dave doesn't know, Dave.
Dave's always available.
I've sent him a couple that I was questioning, like, okay, I'm not kind of a gray area here. I need a little help, and I've sent it to him.
We look at lots of BCIs. And like the next training that I want to do, I want to actually pull some BCIs and redact the personal info and do more of a work group of let's do groups and let's look at them and see what we think. I did have some originally in here and like, it's so hard to see. It's
a good one because some of them
right way to do it, but I do want to do a part 2 where we're actually actively looking at that to see just to work through all of them. So I was pulling out examples last night. I have a stack like this thick printed out of BCIs that we've worked at. And then I have some that are in the computer that I answered. I've never printed on them. So when in doubt, call us. If we don't know, we've reached out to our compliance contacts at DODD. They're pretty quick. getting back with us to say, yep, that person can work, or no, they can't, or especially if there's weird stuff. Every once in a while you'll come across something weird. Questions? And if you forget my name, you can always say, hey, I want to talk to the crazy chicken lady, and I'll answer to that. Like seriously. Question, concern, anything. I know it was a lot of info.
I actually brought me and I wanted to see if you could look at it.
Yes, absolutely. Absolutely.
Can I bring it up?
Sure. I love those kinds of examples, although I might have to go get my rule because I didn't bring that one. Okay, so this is still in the system. It says case pending, so there's a domestic violence and assault charge for this person, January 6th of 2025. Disposition is held, which means it went over to the trial system, so they're looking at the trial. And it says case pending. So if you look up, this is Toledo, so if you look up on Toledo, you should be able to see where it is. With the links that I sent you.
Okay.
And it's one that I would, each time there's a court appearance or anything going on, I would put it on your calendar to check after that.
So technically, he's not convicted, right?
Right.
So we can employ.
Mhm. He has not pled guilty. He has not been convicted. So it could be that they end up pleading it down. It could be that they throw it out. I mean, there's lots of different things that could happen with it, which is why you got to watch, because as soon as he pleads guilty or he gets convicted, then if it's truly these charges, there will be an exclusionary period.
Yeah, that's what I figured.
Yeah. Yeah. All right.
Training came right in time.
Perfect.
Can I give you an off the wall one? So if an potential employee was charged with patient abuse, it was all over the news, but they didn't actually they dropped it down to something lesser, but it's still a felony 4. How are they?
Depends on what the actual code is that they put it down to and where that falls in. And if this is an actual scenario, I would want a little more info from you later because I would want to check to make sure that's okay. Because sometimes people go, okay, it's pled down, it's okay. And it might not be. Because it's not easy to look at these. It's not easy to maneuver through them. So you have some providers that are like, okay, I think they can work, and maybe they can't. So you and I will chat.
So when we're looking.
FYI, I did not hire her, but she is working.
And really, if you find out things like that, those are things you need to report. Because that will get you in trouble if you don't.
My question is, sometimes on, like, let's say there's a date of arrest or whatever, and then there's like a bunch of other dates. I don't know, like, which date am I supposed to look at? Is it the DO or whatever, DOC or something, or the date of arrest, or?
You're not going by the arrest date, you're actually going by the conviction date. So there should be by the conviction. But
OC,
sometimes,
the code?
yeah,
DOC.
sometimes they have multiple ones. So when there's multiple dates by where it says conviction, you want to look back at the court records. They put dates on there, like if they've updated, say somebody paid on their fines, there's an updated date on there. So you have to look at those court records to see what the actual conviction date, because you're looking for, he was convicted of that date or pled guilty on that date.
And we base it off the conviction date, not the date of arrest or the discharge, or would that be discharge?
So the discharge would be, so you have the arrest date, which That's great, but we don't worry about that date. It's the conviction date, and then you're going to the date of discharge. So if you have a conviction date of June 18th of 2007, and it's like a 5-year. You're also going to look at, you're not going to start that 5-year until the
discharge date.
the discharge date, yes. So basically, once they're done with their probation and their jail time. That's when that 5-year clock starts.
Should, new hires, be ran through the SAMS Gov and the ODM database? Or either or?
You have to run them through all 7. Or you could do ARCS, SAM, and ODM. Because ARCS will cover those 5, and then there's the other 2. Or you can run all of them separate. Either way, it's fine.